Hi, I'm going to speak to you about judgment writing. And as we know, judgment writing is one of the critical subjects for any judicial officer because ultimately, upon hearing the case, whether it's on an original trial or on appeal, the final outcome is judgment. So we expect to write judgment. And as we shall see in the course of this lecture, judgment writing, it's an art, and both it's an art and a science. And we all know that when writing judgment, there are a couple of issues that needs to be considered. In the course of this training, I'm going to cover a number of areas as they can be seen in the slide. The first one is to explain the meaning of judgment itself, and I'll proceed to explain why do we need to write a judgment upon hearing of the case, whether on appeal or on original trial. But also something which is also important for participants to understand is what makes a good judgment, what makes a judgment good, how can you tell that this judgment is good and the other one is not good. This is something that we're also going to see in the course of this presentation. And more important also, the components of judgment will be also addressed in the course of this presentation. And I'll proceed also to look on the content of judgment, but also how can you make a judgment an interesting document to read. Because in the course of writing judgment, a judicial officer may write in a way that the judgment will be very attractive to the would-be readers. Important also, we'll look at why should we edit our judgments, but also there's a formula on how to tick the boxes when you're looking at your judgment to ensure that the judgment contains all the essential elements, and that's also another issue that we'll be looking at. We'll also proceed to look at the preparation of judgment, but also the importance of giving judgment, giving reasons when you are composing a judgment, which is also very important and very critical for any judgment that is written by any judicial officer. We'll also look at the common errors or common mistakes, the common mistakes that are committed by judicial officers in the course of writing judgment or in their judgment. That is another. And finally, we'll proceed to a closing thought before we look at the issues that a judicial officer has to consider when pronouncing or delivering the judgment. In terms of course objective, dear participants, the objective of this course or this training is to provide you learners with the essential research, legal, and analytical skills as far as judgment writing is concerned. But also the other objective is to impart to you skills on evidence assessment or evidence evaluation as you progress in writing your own judgment. But also it is important to build the capacity in writing good judgment. Of course, we intend that in the course of training you, essentially to ensure that at least we all have those necessary skills and the capacity to write a judgment which is good judgment, not a mere judgment. When talking about judgment, one may ask a question: what is judgment? And therefore, there's no agreeable definition of what amounts to a judgment. But essentially, judgment means the statement given by the judge or the magistrate or any judicial officer on the grounds of a decree or an order. So there is a decision. You arrive at a conclusion in the course of examination of your case, and of course we all know in a civil case, normally the outcome of any civil case is the decree or an order. So the reason of how did you arrive to issuing that decree, or how did you arrive to a given decision, even if it's a criminal case. So that is essence is the judgment. So all the contents that are contained in a judgment, the essential of all the content of what, how do you arrive to your conclusion, then of course essentially that amount to judgment. For a number of scholars have sort of explained the role of a judicial officer in as far as the adjudication process is concerned. I'll start with Lord Denning. Lord Denning had the following words to say. Of course, it is also projected in the slide you are able to read. He pointed out that the part of a judge or magistrate in that matter at a trial of a civil action is to listen to the evidence that is presented by the parties, only himself asking questions of witnesses when it is necessary to clear up any point that has been overlooked or left obscure, to see that the advocates behave themselves seemingly and to keep to the rules laid down by law, to exclude irrelevancies and discourage repetition, to make sure by wise intervention that he follows the points that the advocates are making and can assess their worth, and at the end to make up his mind where the truth lies. The essence of the quotation of Lord Denning in the case of Jones versus the National Coal Board, which is the 1959 or England reports, the essence of this case, Lord Denning is trying to explain actually that the role of a judge as an empire, a judge or magistrate as an empire, his or her role is very passive. Is to actually to manage the judicial process, and for the underlying words that normally actually he will not interfere as much as possible. He'll only interfere where he wants to clear up at certain points that either are overlooked by the parties in the case or they are left to obscure in the proceedings. But and also forced to ensure that at least advocacy behaves themselves very well in the court and they follow the rules of the court. But also at the same time, he'll ensure that at least issues that are not relevant in the case, they are not brought to the fore, or they are not of course being emphasized, but also to discourage if there are some kind of repetitions. But in most cases, of course, the judges or the judicial officers intervention will be kept to the minimum. But of course, at the end of the day, for a judicial officer or magistrate, his role is to ensure that at least the truth is unveiled in the case, because at the end of the day, we are trying to see among the parties who has the right. So, and that of course, at the end of the day, will take the judicial officer in the course of determining the truth, that the judicial officer will be able to understand the essence of the case, and in the process of what the judicial officer will write a judgment. So that is one of the things that the Denning was explaining in that case. But the other question we have to ask ourselves, dear participants, why do we need to write a judgment? That is one of the very critical questions. Why do we need to write a judgment in a case? You preceded the case, whether it's an appeal or at the trial, the original trial, and then why do we need to write a judgment? But the answer lies in the fact that judicial officers are duty bound to give reasons for the decision that they arrive at. So it's not necessary. It is not sufficient enough for you to say that actually an appeal is allowed, not allowed. It is not sufficient for you to say that the accused is guilt, not guilt. What is more important for a judicial officer is to give reasons for the conclusion that the judicial officer have arrived at. If you find the accused is guilt or the accused is not guilt, then of course you are duty bound to give reasons. If you found that the appeal have been allowed, the appeal is successful, in the sense that the appeal is allowed, again you have to assign reason. And if you find that the appeal is not allowed, equally you have to assign reason for the conclusion. So that in the essence is that normally the judgment holds the judicial officers accountable. We are accountable actually through our own judgments. And the accountability that is upon us, it's a constitutional accountability, is to assign reason for what we are deciding for. And especially for that parties have the right to know why they have lost the case. Even the winner has to understand, why did I win? And for a losing party, that actually will give him or her a logical reasoning as to why is it necessary to appeal. given the reason that the judge or the judicial officer has assigned. If the reasons assigned by the judicial officer in the judgment are sufficient enough, then the losing part may not necessarily need to appeal. But if the losing part finds that the reasoning are not sufficient and they still thinks that is satisfied, then one will appeal and raise the grounds for appeal. When it comes to types of judgment, this is another issue I think we need to all understand. There are different types of judgment, and the distinction of these types of judgment depends on the nature of proceedings. If it's a criminal case, then then that will determine also the types of judgment that will be there. If it is a criminal trial, then for that also determine. If it's an appeal, again that will determine, because if it's a original proceedings in terms of civil, then of course there will be issues that the parties will agree upon and the court will record. So the determination of the judgment will be, as we shall see in the proceeding slides, the judgment has to focus on the issue that the court had to determine. That if it's a trial or it's a civil trial but on appeal, but again an appeal, then whether it's a civil or a criminal, judgment on appeal has to address all the grounds of appeal. If it's a criminal trial, again, of course, the elements of the crime also have to be, those are issues that the judgment must to address, the elements of the crimes which is the subject of the judgment. But again, the other thing that will determine on the type of judgment, it's the number of judges or judicial officers that are presiding. Because we all know that if judicial officers are sitting in panel, then there's a majority judgment and there'll be a minority judgment or a concurrent judgment as well. So this type of judgment will also depend on how many people are sitting on the bench. It is also very critical to ensure that when you are writing a judgment, you don't write a judgment for the sake of writing judgment. A judgment must be attractive. A judgment, of course, must be, readers must be attracted to read, must enjoy when they are reading the judgment. They should not read the judgment as if something very difficult to comprehend. So a number of eminent judicial officers or judges have explained what makes a judgment good to read. Lord Birmingham, on his part, had the following to say: the object of a judgment is to communicate. So if the object of the judgment is to communicate, then for him, he thought that there are certain essential elements that needs to be there for a judgment to be not only communicated, but effectively communicated to the intended audience. And he went further to explain the qualities of an effective judgment. And for him, an effective judgment in terms of communication, he thought there are three issues that needs to be there. One is clarity. That means judgment must be very clear to be understood by the readers. And the other thing, of course, is simplicity. That a judgment must be simple. It shouldn't be very complicated or too complicated. And the third item is that the judgment must be brief. So for him, brevity is one of the critical elements that needs to be there for a judgment to be good. So for Lord Birmingham, clarity, simplicity, and brevity for him, he thought that those are very important for a judgment to be effectively communicated. And it is also important to consider that the court should consider with whom it is seeking to communicate and adjust the style accordingly. You don't need to complicate so much your judgment, because you are not writing a judgment for your own, or you are not writing a judgment for an appellate court, but rather you are writing judgment for the parties. And in ordinary cases, in most cases, the parties are ordinary litigants, so they should be able to understand and comprehend your judgment. Lord Birmingham went ahead to provide some hints as to what needs to be contained in a judgment, and for him actually he called it a good judgment. He pointed out quite a number of issues. There are quite a couple of issues. The first one is that you need, in a judgment, you need an introduction, and that an introduction needs to be a couple of sentences to set out the issues. So normally there are no agreed formula on what should be in the introduction, but according to him, we say an introduction needs to contain a couple of sentences just to set out the issues. And then next you for the summary of the relevant facts, that at least you have to highlight the facts of the case, whether civil or criminal, but also, and then you should go ahead to summarize or set out the relevant law, because in every situation, in any case, there is a specific law that is subject of the determination of the matter. Then you have to summarize or set out the relevant law. You don't need to reproduce or paraphrase all the provisions of the law, but a summary of it will be sufficient. And the other thing, you cite only relevant authorities. Well, you don't need to parade all the authorities in a particular case, but of course, at least if you have few cases, only the relevant ones, then you need to cite them so that you can support, because this is the essence of giving a reason for your decision, and they'll give you the lending. Before you lend, then you must show the relevant authorities. And the other thing which is important, of course, is you have to summarize the competing arguments. The underlying words you say summarize. You don't reproduce all the arguments by the parties. In your judgment, you just summarize the relevant parts of the competing arguments by the parties, by both sides. Lord Birmingham also emphasized the need to take a moderate and nonpartisan style. A moderate and nonpartisan style, this means when you are writing a judgment, you don't need to lean on one side, leaving the other. So you need to adequately address the argument by both parties without necessarily showing your biasness, because at times you may be focusing maybe on one side, especially maybe the winning part or the losing part, but you need equally to address equally both of them, because actually at times this is one of the grounds of appeal that maybe you not consider the defense case. And for most cases, actually, we shall see later, there's a complaint that maybe the judicial side did not consider the defense case. So both arguments must be addressed. And of course, at the end of the day, you have to say, why did you rely on one and did not rely on the other? And then the other item, rely on the force of reasoning to persuade. Basically, that is very important. Reasoning. A judgment must be precisely reasoned. A judgment is not reasoned. It's a mere letter. It's not a judgment in real sense. The judgment must be well reasoned, and therefore that's where the role of a judicial officer, because you are trying to persuade the parties. You want the losing part to understand, but the winning part also to know why did he or she win the case. The other thing that Lord Birmingham lays, that you should think simplicity and brevity. I've just pointed out, of course, in previous slides, simplicity, that the judgment should not be too complex, but also brevity should be brief. It should contain all the relevant information, but it doesn't need to be too long. Don't believe actually in quantity, but believe in the quality of your judgment. So what matters is not actually the amount of words that you've written, but rather the quality of those words that you've written in your own judgment. Dear participants, the next eminent, the Lord Chancellor, also raised some key issues on what needs to be considered when you are writing a judgment, which is a good judgment, so to speak. The first item for him referred to that you need to refer to the parties by their name. Parties, we all know that is something that is actually, you need to refer parties by their name in the course of your judgment. Of course, but I must raise a caution: you cannot refer parties by their name if the case involves, actually it's a question that the case in our case is a case that involves a minor, because minors are not mentioned by their names. There is a circle on how actually you should refer to a minor. You may either refer them by alcohol name or by just the word victim or whatever, as you shall decide in the court. But otherwise, the emphasis that parties should be referred by name. The other thing is to set out facts in chronological order. This is very important. in order for a judgment to be read and be understood and be attractive, the facts has to be referred or set out in a chronological order. Because logical flow is very important when it comes to the judgment. So the reason that we are advising that you should set out facts in chronological order is to make sure that your judgment is written in a chronological order. But also setting out issues in logical order, that is also very important, because in some cases you need to resolve one issue before you go to the next. And one issue fails, then automatically the other one do not need to be determined. So that this is also very important when you are writing your judgment. Make sure that the issues are in logical order. If the issues are dependent on each other, then of course those which are depends on one another, then of course I think it's important, because once you decide one issue in a negative, then of course automatically you don't need to waste time to go to the other issues. For instance, if you say that there was you find an issue that there was no defamation, then you don't need necessarily to go to see whether somebody suffered any damage, because automatically the issue that there was no defamation automatically makes it irrelevant for you to go to the next issue. So deciding the setting out issues in a logical order, it's very important. But the other thing, as I pointed out, to give reasons for preferring the evidence of one witness over another. There may be several witnesses, and maybe you see certain witnesses are not, are not credible. Then of course you must explain, actually, because that is the essence of analysis. In the course of making analysis of evidence, that's where you point out actually the evidence of each witness, the evidence of every exhibit, whether documentary or physical exhibits, and why did you trust one? How did you relate those evidences? So it's very important to say, if you overrule, you find a certain evidence irrelevant, you have to be able to clearly state out in your judgment that maybe a certain witness, or if the evidence contradicted from each other, that's another issue. While using relevant authorities, you must point out clearly. The other thing, of course, as a judicial officer, keep observation on the law to a minimum. Don't overcoat the law, at least, but you have to connect it to the what I call the triangle. That you have facts, evidence, and law. Make sure in the course of writing your judgment, actually you connected the facts in the law and the evidence that was presented before you, and then reason so that at least you arrive to a conclusion. And then the other thing that judicial officers are advised actually to write their judgment as soon as possible. The more you delay to write your judgment, the more you are going actually to write your own thoughts. So in order to avoid writing your own thoughts, it is advisable to write your judgment as soon as you finish your trial or your hearing of the appeal. But at times, if you are able, you can write your judgment as you proceed, because there are things which are obvious. For instance, you don't need actually to finish hearing the case before writing the facts, because facts are always there. And what you are waiting for in the trial is to take evidence. So you can start writing facts here, and of course you can progress writing your judgment as you proceed hearing of the case. It is advisable, if possible, you can do that. But if it's not, then you can. But of course, in any case, you are advised not to be too late in writing your judgment. Once you are too late in writing judgment, you end up writing your own thoughts. Memories will normally fade. You will not be able to remember each and everything witnesses said if it was a trial. Even if it was an appeal, you may not be able to remember every part of argument that the judicial officers, actually, the advocates were raising during the trial. And at the end of the day, actually, at the end, once you have the first draft, you're advised to check if all issues have been covered. That is very important. Once you have a draft in place, then go back and try to read your draft. Go and relate to the evidence on record. Go and relate to the facts or the argument that parties have raised, and ensure that it is everything. No stone is is unturned. That is very important, especially when you are doing the first draft. But you are also advised to revisit your draft. You can read a couple of times. I will advise you actually make sure that you have several drafts. You don't just write once, read once, and then you go and pronounce. Every time, once you write, take your time to relax, put aside your judgment, do something else, and then of course come later. In the course of doing that, you'll be able to perfect your judgment very well. That is very important. And in the course of reading your judgment, revisiting of course your draft judgment, you'll be able, of course, to take out something which is not necessary. Make sure that at least something which is strictly necessary that remains in your judgment. Those which are not necessary, you can just pull and leave them out. But also, of course, you'll be able to sort out in quite a number of grammatical questions and so forth. In terms of the components, there are two components of judgment, and the two important components of judgment, one is the structure of judgment, and two is the content of judgment. When it comes to structure of judgment, of course, judgment writing is an art and both a science, and it varies from one individual to the other. We cannot have a common way of writing judgment. And if you read judgment actually of those eminent lawyers and even senior judges, even in our jurisdiction, you will come to find that each individual judge has his or her own style. So at times it is advisable to see which style of course you want. It is not. It's unlikely that you'll be shifting your style. So when it comes to style of writing or the structure, it varies of course one person to the other. But it is something which is agreeable is that there are certain things that must be there in a judgment. Of course, we shall see. In terms of content of judgment, of course, actually, I think I always say we have a serious problem in the content of judgment and in the structure. Because the structure, of course, they have a couple of issues. Yeah, but in terms of structure, what are the things that needs to be there? As I said before, judgment is like any storybook. As such, it will have actually the beginning, as I said before, the introductory part, which is a couple of sentences, and of course we have a middle part, where the middle part will cover a lot of issues. I think that's where the analysis and everything takes place. And the end part, actually, that is the final part, where you give the verdict, of course, will be given normally definitely at the end. So the most important part in a judgment is the middle part. That's where actually a lot of things will be unpacked in that particular area. These an advised use of headings, but in our jurisdiction, of course, this is still debatable. We don't have judgment with the headings or subheadings, but we don't even number our judgment. Don't put numbers, but also we don't even put footnotes. So, but in other jurisdictions, this is very common. You see in South Africa, in Kenya, in the UK, in other parts of the world they use. But for us in Tanzania, we are not yet there. This is something, of course, still debatable. I think at some point the judiciary will decide, and there will be a specific of course structure when it comes to use of headings. But for the time being, you cannot use headings if you're writing judgment for the judiciary of Tanzania at each given level, from the Court of Appeal up to the subordinate court, let's say the primary court. As I said before, there is no problem in the structure. The structure is not a problem. The most serious problem is on the content, and that's where we shall see of course in the next few slides, where we're discussing the contents of judgment. Normally, the content of a judgment has contained certain essential things, and I'll explain in the next couple of minutes. In the case of Tanga Cement Company Limited versus Christopherson Company Limited, the Court of Appeal, this is an unreported case, the Court of Appeal of Tanzania had an opportunity to discuss the issue of content of judgment. In this case, the Court of Appeal was confronted with a question on whether what was before it was a judgment. And of course, the Court of Appeal said, what are the necessary contents of a judgment after considering this case? And of course, it found out that actually there are certain things that must be there. And in this case, actually the court said that the judgment which was before it, and if it was unfortunately the judgment of the High Court, the Court of Appeal said, well, the judgment in that particular case was not a judgment in real sense, because it had no those essential elements, the contents were not there, and we shall see these contents actually in the next few slides. The High Court, in the case of Timothy Honor, David Honor, again, of course, was confronted and discussed the issue of or the contents of judgment. In this case, the High Court was actually, the High Court had to ask itself whether there was a valid and true judgment before it, which could in law be affirmed or reversed by the district court. This was a case which came from the primary court to the district court. And then the district court decided, and in this particular person who was aggrieved went all the way to the High Court. So before the High Court, the judge who was presiding by the name Sophie J.S. who was the judge of the High Court, upon reading the decision of the primary court, he was surprised whether there was a proper judgment before the first appellate court, which was the district court, upon which to affirm or reverse that decision. And he said that there was no true judgment worth affirming or reversing by the district court. That was the observation by Sophie, that he didn't find that actually what was before the district court was a judgment worth of affirming or reversing. And according to him, he went to say that a judgment must contain the following items, and he highlighted the 4 items. The first one is a concise statement of the case. As we said, of course, in the previous slides, that the previous introduction. So he said, well, a judgment must contain a concise statement of the case. Then there should be the points for determination. Because at the end of the day, judicial officer must be able to say these are the points that will be there for determination later, and then of course should proceed to the decision there and find the reason for the decision. So according to Justice Sophie, these were the 4 components, and in this case, which was before him, he found that the primary court only dealt with the facts of the case, and also the points for determination, and the decision. There was a decision, but he did not find that there was no reason as to why the primary court magistrate arrived with the decision. So in that case, actually, he nullified the decision of the district court, was nullified, and the matter was brought back to the High Court for proper composition of a judgment. When it comes to judgment writing, as judicial officers, actually, you should be aware that a judgment writing, like any other story, it's like for journalists, actually, they have a principle that a story must have the 5 W's and 1 H. The 5 W's, that is what, who, where, when, why, and how. And for a judgment, actually, the judgment must be able to reveal what happened. So that's the concise statement of the case. Actually, has to be able to explain what happened, who were the parties, where did the matter happen, when did it happen, why it happened, and how did it happen. These are key issues that a judicial officer, when composing a judgment, must ensure that actually these are part and parcel of the judgment that the judicial officer is writing. And normally the content will be determined, of course, by case by case. So normally the content of a judgment will differ. There is no unique or the uniform way upon which actually the content of a judgment will be. It all depends. If this was a criminal case, if it was an election petition case, if it's a murder case, if it's a rape case, so definitely of course it will vary. If it was a defamation case, so the content will vary from case to case. But also, as a judicial officer, when you are writing your judgment, there are also facts which are relevant, because at the end of the day, it will be a basis of your determination later on. So what is relevant in one case may not necessarily be relevant in another case when you're writing a judgment. At times, of course, time may be essential, because that will be used actually when I'm determining a case. Maybe times is essential. So we go back to our knowledge in legal method, material facts. So what is material in one case may not necessarily be material in another particular case. So that is also determines a lot in terms of content. The other thing which is equally important, and I thought of course I should also emphasize, I urge you to ensure, at least make sure that you have at least you are very economical in terms of using words. Don't actually, they normally say the best economy is the economy of words. Don't write too much. Don't use so many words. The brief it is, the better. So economy of words, it's very important. But also, the facts should be chronologically organized. I think I've just pointed out in the previous slides. And also summarizing the principle of law if possible. I already spoke about it. You don't need to reproduce the law every time you are referring to the law. It suffices actually to say, just to mention a provision and state the principle that is contained in that particular case. But also the other point to use plain language. Avoid jargon and excessive technical language. It's not very fashionable using technical language when you are writing judgment. As I pointed out previously, a judgment is written for the litigants. It's not for the appellate court. So it's not very pleasing if you're using jargon, using for technical language. Use simple language so that it can be very well understood by the parties, because we are writing judgment for the parties, not for ourselves. I'll give in the next 3 slides, I'll give an example of how judges were writing judgment. Actually, this is an opening statement in a judgment of a case which involved actually one of the contestants, a former beauty pageant, actually one of the contestants of beauty pageant, who was I think she was put in the billboard without her consent, and for her actually she was suing, actually using beauty as the basis of her claim. And this judge started with this opening in his judgment, that beauty lies in the eyes of the beholder, so the saying goes. It is a paraphrase of a statement whose origin is attributed to Plato, the Greek philosopher. This is an opening statement, the first statement that the judge used. And this was a dispute. This is a judicial officer. He was a magistrate. Actually, was sitting in an extended jurisdiction. This was a land dispute case, and this is what he had to say. Fighting neighbors have not yet reconciled the boundary dispute despite the verdict of the district and the housing tribunal. And then he went ahead, of course, to write. For this it varies from one person to the other. Others don't lie. They use the tradition. So this is a rep case also. A magistrate again was started with this phrase. I think a minor was raped by somebody who she knew very well. So he wrote, a girl of 16 years old, alleged to have been put into an awkward situation as a person who had safety was entrusted to turn the hunter. So this was a rape. So he just started this way and then proceeded to write his judgment. And again, another judicial officer, he was writing a divorce case. So he decided to start with a quotation of Lord Denning, which took in this landmark in one of these landmark books. He said, Lord Denning in his book, Landmarks in the Law, Butterworth, writes a passage. So he went to quote the passage. There is no longer any binding knot for marriage. There is only a loose piece of string which the parties can untie at will. Divorce is not a stigma. It has become respectable. One parent families abound. Definitely, this was a divorce case. A judicial officer started with this opening statement. But I should caution actually that when you use a quotation like this, there has to be relevance actually of this quotation with the judgment that you are going to write. You don't just simply make this quotation if what will proceed will not be directly connected or will not be relevant. But it is, I think it is advisable if you are able to do it. Yeah, you just do it. It is exciting to those who will be reading a judgment. A piece of advice, actually, edit your judgment. A judgment has to be accurate. In order for a judgment to be accurate, they need to edit several times. So edit, and make sure that at least you have a checklist of issues. I just said before, once you have your own checklist, you are able to at least verify what is contained, that everything of course is quite clear. And then of course I think this is reducing citation quotation to a minimum. I think I've spoken about the provisions of the law, but also if you quote, you don't need to quote everything. Quote only what is relevant for your judgment. Don't quote everything. I think it is not relevant. It's not necessary. It is less actually interesting to read. Take out anything not bearing direct on the decision, as I think I also pointed out about this. Whatever is relevant to the case, make sure that it is part of your judgment, but not everything. When you're editing, of course, I think it is important for you to make sure that it is all the punctuations are correct. You ensure that it is all the references are accurate. That is very important. In the next slide, actually, I've given an example. For this is if you quote your judgment, make sure what you quote is correct. And this gives a vivid example, is a clear testimony of a judicial officer who did not proofread. This is proceedings on 23rd May 2014. XY was sitting in the quorum appeared in the prosecutor. Strange enough, at the bottom on the same day, it is signed by another magistrate. So definitely this is for the lack of seriousness in terms of force of proofreading documents, because had the judicial officer proofread very well this document, I don't think it was possible for one to be sitting on a case in the quorum and then signing another judicial officer. So I'll quickly discuss about the checklist that I've mentioned. In a judgment, the most critical part that one has to consider in a judgment is the A, B, C, D, E. And the A, B, C, D, E represent those things that one needs to consider. The three that Lord Don Denning spoke about: accuracy, make sure that your judgment is accurate; brevity, make sure that your judgment is brief; C is clarity, make sure that your judgment is clear. If people are not able to comprehend your judgment, then of course you failed if you're to make a judgment, because judgment must be able to be read and understood by the parties. D, your judgment must be decisive. At the end of the day, you must make a decision when you're pronouncing a judgment. But also, E, you have to explain where it is necessary. Then, of course, you have to explain. So this is actually a key in terms of preparation of judgment. When you're preparing your judgment, you have to bear in mind these are issues that you need to consider. The other thing which is also important as a highlight, and I wish also to urge you when you are writing your judgment, when you are preparing your judgment, of course, it is important to prepare yourself before hearing, because the judgment is an outcome of a trial. So if you prepare yourself very well with the trial, you understand very well the issues and the law applicable, and that will make it easy when it comes to judgment writing. Of course, I also advise you to review and summarize your evidence as you move along. You can have somewhere for taking those important things, the observation that will help you in terms of writing your judgment. At times, you are advised to take notes of impression of witnesses and view of cases at trial, and especially taking note of impression of witness. If you think the witness is not trustworthy, then for that you have to appear in the proceedings. You don't just does not come just as a surprise while you are writing judgment. So it is very important. Normally the appellate will say if you are impeaching the credibility of a witness, then that should also appear in your proceedings if the witnesses are testifying before the court. So it is very important to take note while you are proceeding with the case, but also identify the issues early on. You can identify the issues before even the trial starts, and that will make the trial easier, but also composite judgment will be something very, very straightforward and easy. Preparing a note to the structure of the order in which the judgment will take, of course, again, you may even start thinking how the structure of the judgment will be, but also, of course, you can even start thinking how the decision will be as you progress. But of course, you should not have a conclusion, because you will not know until you listen to all the parties. Use the listening chronologies for clarity. Of course, that you are advised to have. You can at least have a list of items. Don't pre-compose the decisive paragraphs. Even if you are writing your judgment in the course of hearing, don't pre-compose the decisive paragraph. You cannot have a decision until you've listened all the parties in the case. So that is something very, very important. But also, of course, using the decisive paragraph, it may also preempt you. It may also disturb you in terms of if somebody sees your judgment, then of course they will be able to see that. So in terms of that is it. So preparation of a judgment, use simple language. I just say that in the sentence. Make sure that one thought per sentence. Don't put so many sentences in one. So many thoughts in one sentence. Use one thought per sentence for clarity purposes. And the other thing which is you are advised to adopt a more informal tone where possible. Don't be too formal in terms of writing your judgment. Equally, I advise you to guard against unconscious bias. When you are writing your judgments, sometimes we have our own unconscious bias. Unconscious bias is a subject of its own. I'll urge you to take time, read so that you understand it. Some people are very unconscious when it comes to gender issues, tribal issues, color issues, and so forth and so forth. So guide yourself against unconscious bias. And the other thing which is also maintain the dignity of the parties. When you are writing a judgment, you don't offend any of the parties. Even if the accused is guilty, don't offend them. Maintain their dignity. And of course, don't consider somebody based upon the social status in the society. So maintain digital. Use IT. Use IT as much as possible. Nowadays, we have artificial intelligence, which can help you actually even in editing. Your judgment in perfecting, you can do that. So IT has a lot that it can do to help you. I always find it interesting actually to use this concession when it comes to the importance of giving reasons. This is actually a decision of the European Court of Human Rights. In the case of Bassano versus Batista, the court had the following to say: the duty to give reasons is a function of due process, and therefore justice, both at common law and under the articles of the European Court of Human Rights. Justice will not be done if it is not apparent to the parties why one has lost and the other has won. Fairness requires that the parties, especially the losing party, should be left in no doubt why they have won or lost. So this actually, it says all about the essence of judicial officers giving reasons. And I said this is a constitutional duty. We are not only giving decision, but we are duty bound to assign reason for the decision that we pronounce. Finally, final checklist, of course, make sure that we've addressed all the central issues. It is very important to ensure that all the issues in the case are adequately addressed, the central issues in the case. Otherwise, your judgment will not be decisive, which is one of the issues in the checklist. And then make sure that you have made factual findings. There has to be factual findings. If you address on something, you need to make factual findings. Of course, don't simply restate the evidence or the statutory test. Because at times, of course, some people will summarize the evidence and say the prosecution have proved the case beyond a doubt or have not proved the case. But rather, you have to analyze the evidence and you have to make factual findings. And the other thing which is equally important, make sure that at least you have to explain why did you come to that conclusion which you are by. And this is very important. At times, of course, people come for review simply because there was an oversight on one of the issues. So make sure that at least everything is precisely taken on board. But also you should ask yourself one question: will the parties understand my judgment? So when you are preparing your judgment, when you are reading your draft, you make sure that at least you are quite sure that parties will be able to understand your case. And of course, as I said before, you have to explain why did you find in favor one party and not the other. This is very important. While of course balancing all the argument of all the parties, but you have to explain why did you find the other party. Our duty is to explain, and this is actually that's why you are signing your reason. Make sure there is proper application of standard of proof. While we all know standard proof in criminal, beyond a doubt. In civil case, the balance of proof is in the preponderance of probabilities. So it's very important that you have to explain in precise manner that you have applied clearly the standard of proof. And also, of course, make sure that the defense case is also considered in your judgment. This is another issue which is we see actually also in the common mistakes and even the previous one. It is very important at the end of the day to show that if the defense side have raised certain issues, make sure you equally address that. And even if you find it is not important, then you have to say, why do you find that if you don't think the defense does not merit? But also in the previous slide, also the standard of proof. You should not seem to be shifting the standard of proof. We know that in criminal cases, the prosecution have the burden of proof. There are situations whereby this burden of proof may shift to the defense, but also when it's shifted, it is not actually it is also only in the probabilities when it shifts to the defense side of the accused. Very important also to analyze facts and evidence in law. This is very, very important because avoid reproducing the witnesses and the evidence of the witness and come to the conclusion that the prosecution will prove the case or not. It's very important. Also ensure that your judgment is free from errors in the form of grammar, spelling mistake, and punctuation. I have already explained the essence of reading several times your draft to ensure that your judgment is error-free. But also the sentence construction should be also clear, because at times if you misspell, you just construct something not well, then it may lead to a different meaning altogether. But again, something is also considered timeliness of delivery of that decision. I emphasize the need to write judgment timely, but also to deliver as soon as possible. Because these judgments, our judgments, actually, there are somebody who is out there, he's being tormented waiting for. He's very eager to wait for the decision. So once the case is determined, I think our role is to hear and decide. To decide, meaning of course you write and pronounce judgment. So make sure you write judgment in time. Make sure you pronounce your judgment in time. In terms of common errors or mistakes in a judgment, the most common one actually, I think, first of all, is the failure to analyze evidence. I think I've raised that because in a decision, we are looking at the facts, evidence, and law. So these are things. Make sure that at least in the analysis, all those are adequately addressed. You just don't reproduce cases. You don't reproduce. There is a difference between reproducing facts than analyzing evidence. So our duty is to analyze evidence and not to just reproduce evidence and come to the conclusion. You must ensure. I'll give an example. I normally say you have a murder case. In that case, actually, there is a post-mortem report. There is a weapon that was utilized. There is also witnesses that. How do you reconcile? How does the post-mortem report relate to the weapon that was utilized or was used in the murder case? How do you connect with the testimony of the witnesses who came before the court? So trying actually to connect those, to analyze, to relate those, you can easily do that when you are analyzing the evidence that was presented before the court. But you don't have a judgment whereby you have exhibits that were tendered, the witnesses who spoke about the test, the evidence, the exhibits were tendered, and then you don't relate them. I think this is one of the critical problems, and we've seen this serious problem between judicial officers, failing to analyze evidence, but also failure to clearly address issues. For the times, you have a judgment where issues were not clearly addressed, or some of the issues were left out without being determined. It's a different actually if the issues were independent of each other. Then of course, if one issue fails, then you don't need necessarily to go to another issue which is actually cannot be determined in the absence of the other issue which you found in the negative. Finally, failure to consider the defense case. I think this I've explained in the previous slide. I don't need to repeat that. There's this closing thought which I like to refer it very much. Rodriguez said in a journal article, in the end, if you cannot explain your result in simple English, there is probably something wrong with it. So this is very clear and very true. If you cannot express yourself very well in your judgment, then something is wrong, because you are supposed to communicate, and communicating effectively, that means parties should be able to clearly understand your judgment from the content and from the substance, but also from the flow in the language. Finally, I think I just spoke about delivery. It is very important to deliver judgment, and this is the pronouncement of judgment. When you pronounce judgment, I believe that you don't start with the result at the end. You cannot say the verdict. You start off with the facts, explain what transpired, and then you can. So results do not come first; they come at the end. But the other thing, keep your head up. At least you should be alive. You should not be reading judgment as if you are not there. And people will even doubt you. Sound confident. You know you have got it right. If you are not, you are reading judgment, and then you don't seem to be there. You don't seem to be, maybe you are far in terms of thoughts. Then of course people will even be doubting you. And speak clearly and at a moderate pace. It's very important because parties needed to listen to you. They need to understand you clearly, and that is judgment is a fate of others. So that is very important. Avoid hostages to fortune. This is very important, dear participants. Avoiding hostage to fortune means you stick to the issues that are before you. At times you have a judgment, you pronounce, and then there are things that you speak by the way. If they are journalists, actually these are things that they'll be picking up. So avoid anything that will be controversial, which is not part and parcel of your judgment. And even if during writing, avoid writing things which are controversial, because at times they take prominence over the judgment itself. So focus on the relevant issues, don't focus on issues that are controversial. Dear participant, by way of conclusion, this is the end of our topic. The topic focused on providing guidance and basic knowledge and skill. It was mainly to guide you on what are the essential things that one needs to understand as far as judgment is concerned. I must confess, judgment writing, first of all, is an art. So you'll find that you're different styles by different judicial officers. You need to adopt yours. The one which impresses you have to adopt. There's no magic formula on how to write judgment, but what I've given you actually mainly is what one needs to consider when writing a judgment, which is good judgment and a proper judgment, but also a judgment that will be exciting and attractive to those who are reading. We know there are those who read judgment just for interest, but of course, primarily we are focusing on the parties that are before us, but also judgment are read by the superior courts, by the appellate courts. Make sure that your judgments are also clear for the appellate court to understand. You don't write a judgment which, if somebody is reading from the beginning to the end, is not able to understand actually the essence of what you are trying to say. Judgment must be decisive. So, dear participants, that is the end of our topic. That is the end of our discussion on judgment writing, and this is applicable to all judicial officers of different ranks, regardless of whether it is an original case or it is a case which is determined on appeal. Thank you very much for listening. I wish you, and I'm encouraging you to go to different references so that you are able to understand more the types of judgment that are there. Thank you very much for listening, and I wish you all the best.